So till now we have understood what is a contract, what is an agreement, what are the differences between them with easy illustration. So now let's move into a little more in depth with the Indian Contract Act. So we have already understood the very necessities or introduction that we need to know in order to enter into the Indian Contract Act. So now we will understand what are the type of contracts that we have under Indian Contract Act and based on their very nature. So let's move into it. Contracts can be classified on the basis of their validity. For example, whether or not they are enforceable in a court of law. So enforceability in court is the very first thing. In order to make it valid, it has to be enforceable by law. The Indian Contract Act recognizes the following cuts. Now we will understand how many types of contract we have under Indian Contract Act or that Indian Contract Act recognizes. First we have valid contract, then we have void, voidable, unenforceable, and illegal. So total we have 5 types of contract in Indian Contract Act. Now we will understand what are these types and what are their essentials. Now let's move into the next slide. So let us first understand the valid contract, which is defined under section 2H of Indian Contract Act, and in 10 we have the essentials of a valid contract. A contract is valid if it's enforceable by law. As I said, enforceability is the very first thing. Section 2H states an agreement enforceable by law is a contract. So the definition of contract is given under Section 2H of Indian Contract Act, which says an agreement enforceable by law is a contract. So the very first necessity to make a contract, there has to be the presence of an agreement first, then it will be later convert into contract which will be enforceable by law. Section 10 lays down the essentials for a valid contract, and the essential that we have that is under Section 10, that is agreement plus legal enforceability equal contract. So in order to make a contract, there has to be an agreement plus legal enforceability. Then we have competing parties. Both of the parties should be competent enough. Just because, for example, we are stating, for example, you are a person of 22 years old and you are making a contract with a 3 years old baby. That is no not going to happen. That is not a valid contract because the other party is not competent. So in order to make a valid contract, both the party need to be competent. Then we have free consent. So the consent should be free. It should be not made out of coercion, fraud, misrepresentation, all the kind of thing that we have discussed in our previous video. Lawful consideration and lawful objection. This is another necessity of a valid contract which we have already discussed. You can refer to that previous video so that you can understand this video more clearly. Not declared void, and it should not be declared void. Now let us understand these key points. Consideration must be present. Section 2D, Section 25, this is defined. Parties must be competent. So these are the sections that are mentioned. Consent must be free. Section 13, 22. Sec must be lawful. Section 23 to 30. So these are the sections that defines uh, the very essentials of a valid contract. Now let us move into this very code. Every agreement is not a contract, but every contract is an agreement. So this is the very question that you gets repeated while dealing with Indian Contract Act, and it is very easy to answer this question if you know the basic traits how to answer this. So this is all about valid contract. Now let's move into void contract, which is another type of contract which falls under Section 2G of Indian Contract Act. A void contract is not enforceable by law. So the contracts that we will consider as void which are no enforceability by law and they are considered as void. It has no legal effect and is void ab initio or voids become void subsequently. It has no legal effect and void ab initio means it is the contract is void from the very beginning itself or later it becomes void. So there's no legal enforceability. No enforceability equal void contract with minor void ab initio. So as I said, you cannot have a contract with minor. Case Mohori Bibee versus Dharmodas. This is the course in 1903. So this is the very judgment that has been given in this case, and this is a very important case that you need to remember at any cost in order to make your answer more scoring. So let's move into void agreement, which falls under section 24 to 30 and 56. Unlawful consideration object section 24. It is void. So now we understand what is unlawful consideration. In order to have a contract, there should be, give and take. So A is selling his house If B offers him drugs instead of money, it is an unlawful consideration and it is a void agreement. No consideration. If B denies to give anything to A, that is also a void agreement. Restraint of marriage is another criteria to fall into the void agreement. Then we have restraint of trade, restraint of legal proceeding, uncertain agreements where the terms is not clear, wagering agreements, and impossible acts. As I said, if two-person in the relationship, he tries, I'll bring stars and moons, you say yes to me, and that is, invalid agreement. This is a impossibility of act. That is a void agreement. So now let us understand through another example. A agrees to get B a government job for 1,000. This is void because there is an unlawful consideration. So when the consideration that the thing you are giving in return is not unlawful, you are selling drugs, you are selling humans, you are selling something which is forbidden by law. So all these would be falling under void agreements. Now let us move into voidable contract, which is falls under section 2I of Indian contract. A voidable contract is enforceable by law at the option of one or more parties, but not at the option of others. Arises due to coercion, fraud, misrepresentation, undue influence. Affected party can cancel or continue. Section 19, consent affected by coercion, fraud, voidable. Now let us understand what is voidable contract. As I said, A wants to buy the house of B. B is not ready to give. If by putting a gun on his head, A says that you have to sell your house to me, you need to sign here now, otherwise I'll kill you. So this his consent is made out of coercion, fraud, representation, or undue influence. There is a B has been threatened by A. Therefore, his consent is not free. And after the agreement, if B states that the consent was not free, this would be falling under voidable contract. But if B denies or stick with the contract, then it will be enforceable. So it depends on the affected party whether he want to continue the contract or want to cancel. So this is the very example of voidable contract. Now let's have a quick understanding regarding the difference between void and voidable contract, because there where the question arises or confusion arises. So we can differentiate them on some basis. For example, void contract, the definition of void contract is mentioned under section 2 of Indian Contract Act, and 2I defines what is voidable contract. And if you talk about enforceability, void contract is not enforceable at all. It is void of initio. It is void from the very beginning itself. So there is no question of enforceability. Enforceable at option of one party. As I said, if B continues to carry the contract, it would be valid. If B denies, then that would be voidable from that time only. Legal effect. No legal effect. As I said, if there is a void contract, there is no enforceability, there is no remedy, there is no legal effect, there is none. If it's void, it's void from all center. Valid unless avoided by aggrieved party. So the contract between A and B regarding the house, it will be continuing either B um, B started giving his statement that my consent was not free. Before that, this contract has the enforceability and will continue as it is. Now let's understand what is unenforceable contract. This is a valid contract in substance but cannot be enforced due to some technical defects. For example, lack of stamp or registration. So this is a technical issue. For example, we have made a contract, we have all the things that is necessary, party's name, consent, declaration, everything, but there is a lack of a particular stamp or registration which would make it valid or legal. Because of that, it is becoming unenforceable. But if we correct that default, it has the probability to be enforced. So that is the very definition of unenforceable contract, because we are missing something on that legal thing. It becomes enforceable once the defect is removed. So if we add all the necessary stamp sign that is required in order to make it valid and enforceable, then it will become enforceable. For example, an unregistered agreement becomes enforceable upon registration. So if there is an unregistered agreement, if we register it, it will be operative. So this is the very classification of what is unenforceable contract and how we can make it enforceable. So now let's move into what is illegal contract. So the very term says illegal means illegal. There is no other definition into that. If it's not legal, that is illegal. An illegal contract is one that involves unlawful or criminal acts. These are void and also punishable under criminal law. So, which is not legal, that is illegal. So, you cannot make a contract which is which has the nature of illegal check and consideration. And illegal contracts are void, but not all void contracts are illegal. So, this is also the puzzling kind of statement that we have. But if we understand what the definition of void agreements and what is the definition of illegal contract, then it is very easy for us to answer this question by our own self. Example, no legal remedy available. So if it's illegal, obviously why court will give you any legal remedy? Because it says it is illegal. So if you don't listen to the court, if there is an issue you are facing, where the court will come in rescue. Example, agreement to commit a crime or get admissions via illegal means. So for example, A reads in you know a college and he has a personal issue with the principal, and B is the other person who is trying to get admission into his college, but no, his percentage is low, that's why he is not getting admission in this college. A has some kind of in a student union or has a person who has powers in his hand. So A said to B, if you can kill or you can break his legs and hands, then I can assure your permission. I can assure your admission into this college. So this is kind of an illegal contract that A and B is having. So this is illegal. It is not enforceable. There is no remedy available. So this is basically a big no in the eyes of Indian Contract Act. So this is a very example of illegal contract. Now let's sum up what we have read till now. Valid, legally enforceable. In order to make the contract valid, it has to be legally enforceable by law. Void, not enforceable, no legal effect. So if it's void, it is void from the very beginning itself. You cannot ask for any remedy thereafter. Voidable, enforceable by one party. Here, as I said, if the consent is not free and later the other person spoke on his behalf that my consent was obtained by threatening me, then that will be voidable. Unenforceable, defective but curable. As I said, if the contract is not registered, that is unenforceable, but if it get registered one, then it becomes enforceable. Then we have illegal, it is criminal in nature and void. Illegal is already illegal if you are selling drugs, if you are selling guns, if you are into human trafficking. All these kind of contracts are illegal and void. There is no remedy available in the court. So this is all about the summary of the kinds of contracts that we have. So that is all about. So if you want such legal concept, to let me know in the comment section so that I can come up with more videos. So that's all for today. Thank you for watching the video. Soon we'll be meeting soon.